Here are the top 5 mistakes people make when trying to settle their Indiana injury case. The first mistake is believing the adjuster. So this happens all the time. People call the law firm and they say, hey, Mark, the adjuster told me I don't have a case, so I'm not going to bother moving forward with you guys because if they're not going to pay, what's the point? Number one, the adjuster works for the insurance company. The insurance company's number one job is to pay as little as possible so they can maximize the value to their shareholders. That's capitalism. That's what it is. So you can't get mad at insurance adjusters for saying, oh, we're going to deny this case or we're not going to pay on this case because they're just doing their job. But believing them, that is the real mistake. So number one, believing the adjuster when they say, hey, we're going to deny this claim. Now, this happens even to lawyers. We get calls all the time. Hey, Mark, can't pay on this claim because your client shouldn't have been walking in the rain. Mark, your client should have paid better attention for someone to blow that stop sign. Maybe they could have stopped. Insurance companies love to make up nonsense. I don't even get mad at that. They're just doing their job. Getting mad at an insurance company for denying a claim, it's like getting mad at the sun for rising in the east and setting in the west. It's nature, right? But that doesn't mean we have to believe insurance adjusters. So don't take their word when they deny a claim. Mistake number 2, accepting an insurance company's low valuation of a claim. This is right there with denial, but they'll say, hey, you know what? There is a claim here, but it's a very small claim. And, well, we just don't think there's very much to this claim, so that's just the facts. I can't change the facts. So, Mark, you got to accept this. Or if you're trying to settle on your own, oh, well, this is a small claim. Don't you agree you could have done a better job looking at it? Who knows what they're going to say? Again, don't get mad at them for doing their job. You have to get paid. Don't ever get mad at insurance companies doing their job. Insurance companies, even if they're being genuine, they misvalue claims all the time. We've had a case, we went to jury trial, got a $3 million verdict. The highest offer on the table was like $350,000. The insurance adjuster literally said, hey, Marc Lopez law firm, your client's in their 80s. We're not going to pay too much money for an old lady. We didn't accept that. This happens all the time too. People slip and fall. Oh, Mark, they should have been watching where they're going. Get settlements, $250,000 against the restaurant chain. Never accept the insurance company's valuation without fighting and making them prove it and doing your own investigation. Mistake number 3, making a too low of a demand offer. With injury claims, once medical treatment is complete, in order to try to close a case, the person who's hurt or their attorney needs to make a demand. Now, that demand is based on lots of things: the medical records, how long the person was injured, how serious the injury was, how it impacted their life, how much work they met. There's lots of things that go into a demand. But the issue is, if somebody that's hurt makes too low of a demand, well, that messes up the insurance company's algorithm, because too low of a demand makes a signal to the insurance company that, hey, the person who's hurt or their attorney doesn't value this case. And if they don't value it, well, we're not going to value it either. And so that messes up all sorts of things. You know, if something changes, if we find out there's more medical records, if it turns out a person's hurt worse than they thought, it's very hard to get more than that initial demand, because the insurance company say, hey, you've already told us you'd accept this. Now you've moved the bar. What's going on? It creates tension. It creates hostility, but also it's yourself to blame because you're doing a bad job requesting the amount of money in the demand. Don't make that mistake of not asking for enough in the initial demand. The initial demand needs to have medical records, medical bills, lost wages. It needs to detail how a person's life has been affected. There needs to be so much in that demand so that you can show and justify to the insurance company why they need to understand this is a serious case that they need to take seriously and they need to pay serious money on. Mistake number 4, not exploring additional sources of insurance. We see this all the time as attorneys, and it drives us nuts. Just think about this for example. We had a recent case that went to jury trial. A lady was walking. She left the store and walking to her car. It was raining. A driver of a vehicle was loading up her children and groceries, got into the car and wanted to take off. But they backed up so they can move forward around something else. But when they backed up, they hit our client. The client was seriously injured. Now, the person that hit her only had minimum coverage. They had $25,000 to cover broken bones, hospital stays, rehabilitation. That's not nearly enough. And so we also went after the store that she left for having improper lighting, improper ingress and egress, basically entrance and exit. And then we also explored our client. She had automobile insurance and she had an umbrella policy that covered things specifically like this. So whereas loser attorney or maybe someone that didn't understand what was going on would have said, well, the most there is $25,000. This law firm was able to find $2.25 million in coverage for this woman's injuries. And that was absolutely life-changing. And if anyone needs to know, $2,250,000 is a whole lot more than $25,000. It's also maybe a message we should have our own insurance and not count on some stranger to have enough insurance coverage for us. That's food for thought. We always have to explore alternative and additional sources of insurance when you're making bodily injury claims. It can literally be the difference between not being taken care of and being taken care of properly. The fifth and final mistake is not getting experts involved. There are experts across the country, but basically these people are learned individuals, professors, engineers, all sorts of just practical experience. But Indiana has something called an expert witness. And basically they can give an opinion to the jury or fact finder, insurance company, and say, hey, this is or is not right. So we use experts all the time in car crash cases, slip and fall cases, any case where we're trying to prove that something was not done correctly. Now, not every car crash case needs an expert. Person blew a stop sign. You don't need an expert for that. You can take that to the people's court. But with slip and fall cases, a recent example here at this law firm, we had a client who was at an establishment that served alcohol. And this establishment had an outdoor patio area, and it was not level. It was on a grade, and this place did not have a handrail. So they're serving alcohol outside on a slope with tables and encouraging people to sit out there and drink. Inevitably, somebody, our client ultimately, fell, and because it was on a grade, he rolled, and there's no handrail, he injured himself. And, well, maybe there's an argument, well, he was drinking. Well, they were serving him. It was their ability to maintain it. He's an invitee. An expert determined that, number one, various building codes were not honored or subscribed to, needed a handrail. Additionally, the slope was far too slopey for an outdoor establishment that served alcohol. So experts are absolutely essential in cases like slip and fall, but can also be essential in car crashes or any type of case where somebody is saying, hey, not really an injury, or hey, that person really didn't do anything wrong. Not using an expert is something that we see that hurts people in getting the maximum compensation for the Indiana injury claim. I hope you've enjoyed this video. If you've watched this far, please subscribe. Here at the Marc Lopez Law Firm, we understand that people who have been injured by the actions of other people experience a lot of frustration in dealing with their case. Allow the Marc Lopez Law Firm to turn that frustration into compensation. Give us a call, 317-632-3642.